How should progressives interpret the Constitution?
Well, I think no one, or at least no one we take seriously, uses only a single method to interpret the Constitution. Isaiah Berlin was famous for saying the hedgehog knows one big thing and the fox knows many things. And I think liberals, and I think everybody who interprets the Constitution honestly, is kind of a fox, like me. So what are the different methods that people use? Well, obviously you start with the text, the words that are written on the page. And sometimes those words are pretty definitive. So for example, we know that Arnold Schwarzenegger or Jennifer Granholm can't be president because they're naturalized citizens, and the Constitution says only a natural-born citizen. But even there, you have to sometimes interpret the words in context. So Bill Clinton was born in Hope, Arkansas, so he was a citizen from birth. But he was born by cesarean section. Does that mean he's not natural born? No, of course not. So you read the words in context, and that's where you start. And then obviously, one of the big questions is, well, what did the framers, what did the people who wrote the words think? And there, I think it's really important to understand, this Constitution didn't just have one framing, 1789 through 1791. It also had a huge framing right after the Civil War with the introduction of the 13th, 14th, and 15th Amendments, which are profound changes in how the federal government and the state governments interact, and profound changes about the commitment of America to racial equality. But even if you're asking, how should we interpret the words based on what the framers of the words think, you have to answer the question, why should we care about that? Maybe the framers wanted us to interpret the words in light of our experience and our understanding. So when the Constitution says that the Eighth Amendment forbids cruel and unusual punishment, are we really asking what they thought was cruel and unusual in 1789 or in 1870? Or are we asking, what does our understanding tell us about what the words cruel and unusual mean today? And of course, many of the things that are in the Constitution, they fail to anticipate. So when we ask, is it an unreasonable search for the police to stand across the street from your house and use a thermal imaging device? Even Antonin Scalia said yes. Why? Because there are principles of privacy in the Constitution. Not because you ask, if James Madison had had a thermal imaging device, what would he have done with it? Or if James Madison had been asked about violent video games, what would he have thought? That's an idiotic question to ask. Or it's a question that has an answer only that we think he would think what we think today. So there too, it's very hard to say what they understood. And of course, understandings about society have changed. So the same people who proposed the 14th Amendment segregated the galleries in front of which they debated these issues, and segregated in the schools in DC, which they were responsible for. Because they didn't understand, as we do, that it's not equal protection of the law to treat people differently on the basis of race, because race is a morally irrelevant criterion. So, of course, text and original understanding play some role, but they don't answer some of the hardest questions about what the Constitution should be interpreted to mean. And then on top of that, even if you're thinking about the text and the understanding, you also have to look at what Charles Black, the great legal constitutionalist of the mid-20th century, said about the structure and relationship between the different pieces of the Constitution. So you should look at the pieces in context, and you should ask about some of the big principles that underlie the Constitution. And here, I'll just point to one of them that I think is really critical. It's one that John Hart Ely, a great constitutional law professor of the latter half of the 20th century, pointed to, which is that the Constitution is profoundly a document about getting a democracy up and going and surviving. And so he said you should interpret the Constitution not in a clause-bound way so much, but in light of the fact that it's a representation-reinforcing document. So what does that tell you? It tells you two things that are really important. One is, when you interpret the Constitution, you should interpret it in a way that keeps the channels of political change open. So you have to be much more vigorous in policing the attempts to prevent people from voting or prevent people from speaking freely than you have to police things about how banks should be regulated or the like. And you also have to protect groups that can't protect themselves in the political process so that they can become citizens, so that they can become participants in the process. And that's a really important thing as well. Fourth, you need to think about precedent, because even though we're very confident, all of us, always in our own beliefs, it's important to recognize there were wise heads who thought about these things before. And it's important to understand, as the Supreme Court three-judge opinion said in Planned Parenthood against Casey, that generations of Americans organized their lives around an understanding of what the Constitution protects. And there, for example, a generation, indeed, I'm old enough to say 2 or 3 generations of American women have now organized their lives around the idea that they control their reproductive capacity. And precedent tells them that, and reliance tells them that. And finally, you have to interpret the Constitution in a way that makes pragmatic sense. The Constitution is not a suicide pact. Even Justice Scalia, in his ostensibly textualist and originalist opinion in Heller, the D.C. guns case, said, well, of course you can't take a gun into a courtroom or into a courthouse. Why not? You can speak in a courtroom or a courthouse. There's a famous Supreme Court case, Cohen against California, that says you can wear a jacket that says the draft into a courthouse. So why not let people take guns into courthouses? Because it's a really bad idea, and even people who claim to be textualists and originalists don't interpret the Second Amendment in a way that creates those kinds of dangers. So all of those are ways of thinking about the Constitution. And the other thing that's important to remember is who interprets the Constitution. It's not just the Supreme Court. It's not just judges. Every public official in the United States takes an oath to support and defend the Constitution. And when they do their jobs, they need to think about what the Constitution forbids, even if no court is ever going to tell them it forbids that. And all of us as citizens, we interpret the Constitution as well. If you want to know who's had the biggest effect on what the 14th Amendment and its enforcement clause reads, don't just look to judges on the Supreme Court. Look to students like John Lewis as a 23-year-old who put their lives and their bodies on the line to change how Americans think the 14th Amendment applies or the like. So I guess the key takeaway from all of this is that constitutional interpretation is not a mechanical act. Sometimes, especially when they're in front of the cameras, judges act as if it is. So the first Justice Roberts on the Supreme Court during the New Deal wrote that the judicial branch has only one duty: to lay the articles of the Constitution which have been invoked beside the statute that's being challenged and decide whether the latter squares with the former. It's kind of like what you do when you make a pie and you put the crust on top and then you cut away the edges. Or the current Chief Justice Roberts, the second Justice Roberts on the Supreme Court, says being a judge is like calling balls and strikes. Well, that metaphor doesn't even make sense on its own terms because, of course, if you look at what umpires really do, they call balls and strikes. But let me read to you one of Major League Baseball's rules, Rule 7.06. It says that if a runner claims there's been interference in the base path, the umpire should award the runner, and here I'm going to quote, the bases they would have reached in the umpire's judgment if there had been no obstruction in the base paths. That calls for judgment, that calls for equity, that calls for understanding that people should have a fair opportunity to run the race. And more fundamentally, as I suggested at the beginning, there's never been only one clear, legitimate, and timeless method of interpreting the Constitution. Throughout our history, since the founding of the Republic, arguments about the Constitution have relied on text, they've relied on original understandings, they've relied on structure and relationship, they've relied on precedent, and they've relied on arguments about what does our most important document mean to us today as citizens and as residents of the country. So we've always had a Constitution that's evolved to meet the felt needs of the American people, and that's not going to change.